Hi, this is me Kamal Raj Kandel. Today we're gonna talk about the video presentation of business law. I'm gonna talk about the contract law issues, and then my friends will be talking about more about the law. So this case seeks to determine whether there was an offer in the case where Beauty and Beast Salon sent a cellular advertising manicure and massage service for $10. Jenny responded and visited the salon, but the management assisted that she could receive the service at the cost of $100. Thank you. My friend will be talking about the rules of the contract law.
Thanks, Kamal. So, it's me, Bibek Thapa, student GIA 3029, and I'm here to talk about the rules for the case. So, when the contract law is considered, there is no offer to sell in an invitation to treat, and hence, its objective is to inform the public about the products and prices through circulars and any other channel of communication. So when there is an invitation and the other party offers to purchase the product or services, then the seller will be at liberty to accept or decline the offer. So that's all I'm talking about for this law, and I'd like to call my fellow friend Prajisa for talking about the application.
Thank you, Vivek. Myself, Pratisha Manandar, and my student number is NPS 2221. Today I'm going to explain about the contract law and their application. According to the Pharmaceutical Society of Great British versus broadcast chemist and influence verdicts on the nature of a legal contract, the court rules that the price attached to the product that is displayed in a store is not accurate to the institute and offer, but it is just an invitation to a treat. From the number of a case that involves a Pharmaceutical Society of Great Britain versus Booth case, Chemist Ltd, Harris versus Nixon, Harbour as Patrick versus Chandler, Smokeball versus Fisher, advertisement, and the advertisement to sell a product or service is not an offer but an invitation to treat, thereby highlighting that there was an offer in a Jenny's case. Thank you. And my friend Nafi's gonna explain.
Hello there, this is Syed Nafiz here, and I'm here to present a business law presentation. My fellow friends already spoken about the application rules and the rules application and the issue of a contract law case. So what I'm going to do discuss about the conclusion. So here what happened here is the case about Jenny. She has the invitation from a beauty salon, and so Jenny has received an invitation from a beauty salon, and the message in that invitation were not correct price, because she has got the price that is only $10, but it's supposed to be $100. And then when she went to the beauty salon, what happened with her is she has got the wrong because the poster had the wrong price tag, and it was only $10. Then she tried to complain against the contract because against the advertisement, but what happened here is there wasn't any contract between two parties. So Jenny is a plaintiff and the beauty salon are the defendant. As because there is no contract, Jenny cannot claim that the plaintiff, the defendant party, has to offer the same price as mentioned on the invitation of the advertisement. So what happened, Jenny cannot actually call for any compensation from the beauty salon, but to maintain the beauty salon's reputation, they can offer her that same price of $10 just to treat the customer as king. Thank you, and then we will start about our next consumer law case.
Hi again, this is Vivek here. So I'm here to talk about the issue for the consumer law. So this case involves Rowland, Owen and Restaurant Private Limited, where the issue at hand is whether Owen can seek legal redress in regard to breach of implied warranty. So for the rest of the presentation, I want to call my fellow friend Susan. Thank you.
No problem. Hi, thank you, Vivek. Hi, it's me, Susan Karki, and my student ID is EMB21047. And we are talking about the consumer law. And my friend just talked about the issue of the consumer law. And now I'm going to talk about the rule of the consumer law. And under the Australian consumer law, an explicit warranty is where manufacturers and suppliers make extra promises either in writing or orally that the product will meet the intended performance, condition, state and quality of the product. Implied warranties and entail promises that emanate from the characteristics of the transaction and how the consumers inherently understand them rather than from express portrayal of the product and service by the seller. Basing on the customer guarantees regarding to the acceptability of the good, there are two clauses of implied warrant that can be considered, and these are guarantee as to acceptable quantity as 54 and the guarantee as to fitness of goods for any disclosed purpose as 55. Thank you, and I'm going to call my friend Prajisa for the application.
Thank you, Susan, for the introduction. So I'm here to explain about the consumer law. Under the Australian consumer law, there is always a warranty, either orally or written, that the product will meet the performance, conditions and quality of the product. From the analysis of the case, over Rowland can indicate the legal action against Restaurant Private Limited for breaching its implied The legal case is related to implied contract in regard to quality of product and fitness of goods for an disclosed purpose are David Jones versus William Denny versus Ford Motor Cooperative, Casual Electronic versus Toshiba Singapore Private Limited, Xerox Printing Equipment, and so on. For the own case, there was a breach of warranty based on the quality of product and fitness of goods for their intended purpose. Thank you. So my fellow friend Nafi is gonna explain the conclusion about the further case. Thank you.
All right. Hello there. I'm going to speak about the conclusion of consumer law. So what happened here, Owen Rowland, he initially purchased 2 ovens for his restaurant, and then what happened when he has got the ovens from Restaurant Private Limited, and he didn't really check the warranty or guarantee what is related to the ovens, but in terms of getting the ovens, he only looked for bargain price. So in this case, but he wasn't too sure about the warranty or guarantee he is getting from Restaurant Private Limited. Restaurant Private Limited gave the ovens for really bargain price, and thus it doesn't have any warranty or guarantee. But in terms of Australian consumer law, all the product must come with some warranty or guarantee, and it doesn't have to be written, it can be done orally. So what happened here, Owen Rowland can initiate legal action against Restaurant Private Limited for breaching its implemented warranty, and this can be based on guarantee as a acceptable of quality, and guaranteed as to fitness to good for disclosed purpose. However, given that Owen had initially stated his purpose for purchasing the oven as is, clause cannot apply. So here what happened, when have got the oral warranty from the company, and he cannot use the purpose of his whatever his reason for the case to go against Restaurant Private Limited. Thank you.
Hi again. This is all about the consumer law and customer law we have to talk about. So my fellow friend talk about the issue, rules and application and conclusion. Thank you. Hope you enjoy the video.